Welcome to the monthly truck stop webinars provided by the Motor Carriers Insurance Education Foundation. Truck stops are provided the second Thursday of each month at 2 p.m. Eastern Standard Time. These webinars are presented as industry updates for information purposes only and do not qualify for state CE credit. If you're seeking state CE credit, visit our website, MCIEF.org, or email us at mcief.mcief.org. And we can give you the CE programs that the foundation provides. If you have any questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar by email. If you experience any audio problems, please send us a note in the chat window at 800-741-4084. We will attempt to correct the problems as soon as possible. May 2021 update. We have our friend Jay Taylor who's going to lead this discussion, and he has his comrade here. Jay, say hello to everybody. We see your picture here with your unshaven face, but that's okay. We'll clean you up by the time the conference gets here. And introduce John. I think this time we've had any relationship with John, right?
Yes, so thank you, Tommy. Thank you for the introduction. And yes, this is my COVID beard look. I joined the crowd and I promised to clean up for the conference. So, and by the way, I want all your listeners to know that, and it may be a rumor, Tommy, but I feel almost compelled that your listeners need to know that, is it true that you're opening your own XM radio show called Son of a Trucker? This is a rumor I'm hearing, so maybe we should come back to that later. Say hello to John Marchione. John is an attorney with me. John is in our litigation group, leading over there, and also in our Tampa Bay office. So John's going to give us some really good information today on probably, I would say, one of the most important cases in recent history here in Florida. And we'll tie that together with some of the other things we're talking about. So welcome, John.
Thanks for the intro, Jay. Thank you for having me, Tommy. It's nice to be here.
Well, we appreciate that. Now, their contact information will be in the last slide, so we'll get there. Jay, we've been hearing a lot about tort reform. The ATA is talking about it in reaction to these nuclear verdicts and reptile theory. And we know some states have addressed it, one of our home state here in Florida and some others. How about updating us on what's happening with that tort reform, if you would?
Yeah, I will, and you get the dime tour here. So I'm going to go through some of the legislation, and what's important about this is that, and what we're looking for is a trend in tort reform, not only here in Florida, but across the nation. So let me start with this. No surprise, Florida has passed what's called the COVID Business Liability Shield. That's Senate Bill 72. We passed that March 29th, I believe it was. And basically, what the COVID Business Liability Shield, this legislation does, is it protects companies, our motor carrier companies, and absent a showing of gross negligence, there is no claim. Gross negligence. Now remember, Tommy, normal negligence is what a reasonable. Gross negligence is something more. It's not quite criminal. It's something less than that. So it's somewhere in between. Gross negligence is a high bar, Tommy, and so that's good. So unless the plaintiff can do two things. One, have a physician's affidavit of merit. It provides some type of nexus between the COVID claim and the employer's actions. Number one, a doctor. Remember, that sounds a lot like what? Medical malpractice requirements of doctors' affidavits. So that's a good thing here. And then even there, if they can try to show some type of nexus between the plaintiff's claim and the employer's actions, it has to be gross negligence. And so as long as companies are following the rules and doing reasonable protections, then they're probably protected. So that's a good thing, and that passed. That's good news. Let me tell you about some things that didn't pass, but are very important and will lead into, from the statutory side over to the case law side that John's going to share us with. Senate Bill 846. This is what we call the inflated medical damages bill. And I call it truth in damages. When we were up lobbying with the Florida Trucking Association up in Tallahassee, there was a trend. The buzzword was what? Transparency. We're not trying to keep plaintiffs from having a claim or shield their access to the court. All we ask is transparency. You can't put 20 million on the board when that's not your real damages. So we want to understand what it is, the actual amount paid. What and is that payment usual and customary? So that's Senate Bill 846. It died in the Health Policy Committee at the end of legislation, our period. So we're going to make another run at it. Senate Bill 54 repeals the no fault and requiring bodily injury. Senate Bill 1750, another important one that your listeners want to hear about, is litigation, financing, consumer protection. We've heard, Tommy, a lot about these litigation financing, these plaintiffs' cases. Basically what they do is
explain that part of it. You and I are very familiar with that part, but these companies, I even think Harvard has invested some of their trust in one of these companies. I read about 5 million, I read there, but this is how they make money of these cases as an investment. You might want to explain that to the participants in case they're not up on that.
Tommy, this industry kind of makes your skin crawl, but basically what it is a litigation company gives money in advance. It's a non-recourse cash advance, in fact, that's to the plaintiff in exchange for an assignment of the proceeds of that civil action. And so, this litigation financing just really wanted, again, transparency. The people in the box, the jurors, the folks that are making these decisions, the court decisions about liability, should know this, and it should be regulated. So this litigation financing protection requires registration of these finance companies like banks with the Department of State, and they have to have a bond. I think it's $250,000 bond under this legislation. These companies are not allowed to do an attorney referral. You got to cap the interest rate. I think something like 10%, something along those lines. So that's really important to our system, to keep the integrity of our system, for this to be transparent as well. So I believe that also died in committee. And so,
Jay, what that allows is it not for the attorney to have more money to fight the case, and the plaintiff gets a little bit up front, so they're not quite as anxious to have to settle at mediation or something, because they're getting something up front, and now instead of waiting for the court system, which gives it longer time to go, a lot of cases to the jury versus settling earlier. Isn't that the bottom line to these things?
Yeah, it finances, if you will, and then it becomes what? All about attorney's fees, Tom, at that point. And it causes, I think it jeopardizes the integrity of the system, and people are becoming, our listeners and the general public are becoming more and more aware of this stuff going on. And it's not really, who's running the show here? Is it a litigation making decision, litigation finance company making the decisions? That's a problem, isn't it? So stay tuned on that. We're going to make another run at it. I'm going to give you one more House bill. It's really important in the trending statutory wise. What we're looking for, not just here, but in other states, is, and I actually helped with this language, it's House Bill 57. And I'm going to read it to you just really quickly, because I think this is something we want to support. And at the end, I'll tell us how. It actually makes a change to 316.302, 14A. It says this: the deployment, implementation, or use of a motor carrier safety improvement by or as required by a motor carrier, a related entity, or a third party, including by contract, shall not be considered when evaluating an individual's status as an employee or independent contractor or as an adjoining employee. What does that mean? So all of the misclassification, all of that litigation, think about California, think about all of those class actions, those types of things. It says this: hey, you can't require a motor carrier to be safe and then use that against the motor carrier when you're looking at classification of independent contractors. So we developed this language, we worked on it, and others worked on it, of course, and it didn't make it through in this latest amendment. So we're going to continue to work on that as well. So that's Florida. I want to tell you about Texas because you'll see a trend here. I could talk about New Jersey. We could talk about many different states of what's going on there, but pay attention to Texas House Bill 19, which Tommy, I think we found out yesterday or the day before that it's passed the House, passed the Senate with an amendment, so it goes back to the Texas House, then for final approval, which we're hopeful that it'll pass. But listen to this. What does this House bill do in statutory tort reform? It basically makes these cases, Tommy, two-phased. There's two phases. The first phase, the plaintiff must prove that the driver was negligent. We don't talk about the motor carrier company. So all this reptile stuff, Tommy, goes away in that first phase. And they have to, all we can show is, all the plaintiff must show is the fault of the driver. They can't talk about maintenance and those types of things with the driver. Let's say the driver is found negligent. Then it goes to the second phase. Now the motor carrier company is included in training and those things come out, but it's still got to be gross negligence. And it has to be unanimous rather than the normal 10 to, right, John 10 to 12 to get it. So it's an important bill. It could change the face of Texas litigation when it comes to motor carriers. Some, Tommy, on the other side, some folks say that, well, maybe it could be worse. Now you've got a guilty driver, if you will, and now it's just damages over here and they stick it to the motor carrier. But we don't think so with the standard if it remains as is. I don't know what the amendment is that came back from the Senate because it is so fresh, but we're hopeful. What is all this about? I'm pleased to see the organized, growing movement for true tort reform. And by the way, Tommy, the buzzword is curbing lawsuit abuse. That's what it's called. We don't say tort reform anymore. Curbing lawsuit abuse. And so you see it in Florida, you see it in Texas, you see it in other states. Now your listeners have a flavor for what's really going on in these bills and the push year over year to get that done. So I hope that's helpful and informative.
Yeah, Jay, two other things that they might just remind me. When we talk about tort reform, it's tough to do it at a federal level. You got to do it state by state. And it's what you're showing here, because I understand it's also being proposed where Iowa and a couple other states here, the local trucking associations are very active in this area. And one thing we can do as an insurance industry, since I don't want to use the word benefit us, it clarifies what we're doing when we insure a trucker, because the benefit will pay what we're due anyway. But it's just, so I don't want to say it benefits us, but at least gives us more of a definitive when something happens, how we handle the cases here. But we need to support our local trucking associations and have our senators or local House and Senator state know that we have an interest in this part of it. And again, it's not to take anything away from someone who's damaged, but it makes us more able to address those damages in a known way, in known commodity. So I think that's what's the takeaway of this, is it not, the national effort?
Yeah, it is. And you said something really important, and I said it earlier, but I'm going to emphasize it again. Obviously, tort reform hasn't moved like we wanted it to. And so maybe we should be saying something different, right? Maybe our narrative needs to be different. And that's what I'm trying to explain with these bills. Again, it is nobody, none of your insureds, none of your insurers, certainly not your motor carriers. All of these industries are responsible, and we do not want to chill any hurt person's access to a court. That is not what we're talking. All we want is transparency. We want proof in damages, because I can tell you, these insured motor carriers, they want to take care of these people. They want to do the right thing if it's their fault. But when the numbers that they splash up on the board have no reality and they're inflated, well, that's what causes premiums to go up, drives insurers out of what we call the hell holes. Florida's a hell hole. And That's why we're doing what we're doing. So again, we just want the truth. That's all we want.
Right, that's the part of here. Very good. We finished this slide, right? We'll go to the next one.
Yeah, let's advance on. And so, and I talked about what's working, what's not. You heard a little bit, and you've heard the narrative now that we're carrying. And so that's kind of, if you will, in the legislative world, what's going on as a flavor. But also, keep in mind, Tommy, tort reform can come in the legislative way, but also it can come in case law way, in that sense. And here in Florida, we had a very, very important case. We've talked a little bit about the statutory tort reform, but we can also curb lawsuit abuse in the case law by setting good case law. We're so excited to tell you about a case here in Florida. Again, as I said earlier, probably one of the most important cases of recent history here in Florida. John and I published recently on this case, and I think, Tommy, that's one of the reasons for your truck stop today. So with that, again, say hello to John Marchione, who's going to tell us about this Wilson Art case and kind of what the rule is and where we're going. So go ahead, John.
So yeah, let me start by setting the facts, because the case comes in a fairly common fact pattern that I think we see in some of these accidents involving commercial motor vehicles. So the defendant driver, Mr. Rosario, is traveling on a 6-lane highway in Osceola County. He's pulling up to a light, slowing down. He's perfectly controlled. He's in his lane. He's in the center lane, traveling eastbound. And he is hit from behind by Mr. Lopez. The force of the accident drives Mr. Rosario's truck forward a little bit, and he ends up hitting the person in front of him. Wilson Art, who's the employer of the driver of the commercial vehicle, Mr. Rosario, and Mr. Rosario are sued. They're not sued by the car that they hit. They are sued by the person behind them who hit them, Mr. Lopez. Mr. Lopez unfortunately dies in the accident, and the accident the impact was pretty substantial. And so his estate ends up filing suit again against Mr. Rosario and Wilson Art. And fortunately, the Wilson Art vehicle is equipped with a forward-facing dashboard camera. So they have footage, which I think quite clearly, according to some of the opinions that come out of here, the footage quite clearly shows that the driver, didn't really do anything wrong. He was controlled, pulling up to a light at an appropriate speed, and was hit from behind. His attorneys, appropriately, in the trial in the case at the trial level, his attorneys moved for summary judgment. Now, summary judgment at that point, when they make the motion in Florida, is a very difficult thing to obtain. And they have the video, so they basically proffer the video. There is a presumption in Florida that if you are rear-ended, it's the fault of the person who rear-ends you. So they're relying on that presumption. They're relying on the video, and the trial judge says, sure, and grants summary judgment in favor of Wilson Art and Mr. Rosario, notwithstanding that at the time the Florida standard is really, really strict. But the judge somewhat ignores that at the trial level, and in light of the video, which apparently was very compelling, just dismisses the case against Wilson Art and Rosario. He grants summary judgment in their favor.
John?
Yeah.
I'll make a point. The reason it's so hard to do is if there's counter evidence, the judge will say that goes to that's a matter of fact. The jury has to decide.
Absolutely, Tom. So I'm getting to that, right? Yes, I'm going to get to the standard because the case goes up to the Fifth Circuit on appeal, and the Fifth Circuit says, hey, wait a second. Our summary judgment standard is not as liberal as how the trial court applied it. The Fifth Circuit, and you can tell when you read the opinion, the Fifth Circuit doesn't like it. They don't like what they're about to do, but they're very constrained by Florida's, at that point, their sort of draconian summary judgment standard, which says if there's any counter evidence, you cannot grant summary judgment. Now, what was the counter evidence? So when the motion for summary judgment was made at the trial level, the plaintiff's attorney turned in an affidavit from an eyewitness, and then they had an expert affidavit, which basically relied on the eyewitness account. All of that said that I think evidence suggested that the driver was not necessarily in the center lane, and potentially could bear some fault for the accident. So that's what the plaintiff is relying on in defending against the motion. And all of that evidence that the plaintiff is relying on is completely contradicted by the video. The video shows that the driver didn't do anything wrong. The plaintiff found somebody. They have an eyewitness who said, he saw something different than the video, which was uncontested. So the Fifth Circuit says, well, because that evidence exists, even if it's contradicted by a video that nobody is questioning as being authentic, we have to, under our current summary judgment standard, we have to reverse and send it back. You cannot grant summary judgment in Florida at that point if there is a scintilla of evidence which contradicts what is a genuine issue of material fact, which obviously who is responsible for the accident being certainly a genuine issue. So the Fifth Circuit says, we don't like it, but we're going to reverse and send it back. But because they didn't like it, they certify it up to the Florida Supreme Court, and they certify it up on a very limited. The way that they phrased it was a limited exception. They said, hey, maybe when there's video evidence, maybe we could not use the Florida standard and use somewhat of a more liberal standard. And it goes up, and the Florida Supreme Court takes it on. And I guess not liking the case either, the Florida Supreme Court says, we're going to broaden this. And they take the opportunity not only to answer they don't even answer the certified question. They go beyond that. They completely change the Florida summary judgment standard and adopt the federal standard. Under the federal standard, it's a little more liberal. You don't just get to put on a scintilla of evidence contradicting what is a clear video, for instance, and get to deny summary judgment on that basis. The new standard is, when there's two different sides of the story, and one of which is blatantly contradicted, if no reasonable jury could believe, in this case, the plaintiff's evidence, then the court shouldn't adopt it and summary judgment should be granted. This is a much more common sense approach to summary judgment motions. And the Florida Supreme Court uses its rulemaking power to amend what is a procedural rule. So it's Florida Rule of Civil Procedure 1.510, a little technical there, but they rewrite the rule basically, and they say on May 1st, 2021, we're going to go forward with the new federal standard. We'll work out how exactly we're going to word it, and they do, and they did, and it is now the rule in Florida. And so that's where we are. The Florida standard is now the federal summary judgment standard.
That's important. I didn't like the word liberal. You talk about more factual as that part of it. Exactly what happened. So I don't want to get into politics either side of this equation here, but that's what you're saying. So this means, and getting dismissed early on saves all the cost of defense. That's the part, and will save lawyers' fees and other things. That's what they need to come away from here. And so it's very important to establish those as much facts as we can, which leads us into the next discussion that we have here, this case. And because it's, John, one other thing, so the audience, because it's the federal standard, what we're just talking about would be useful in most all other states, or when it can be removed to federal court, which is an attempt that a lot of plaintiffs attorneys, defense attorneys try to do, particularly for cases involving transportation with all the regulations, because the federal court seems to understand it's better, or have more standards for witnesses and experts and things like that than the state court. So this would be applicable in Florida, both in federal and state court, but it'll be applicable in other states the same way, and would always be useful in federal court, correct?
That's good. Well, that's largely correct. In federal, so all the federal courts use this standard. It's the rule that's set forth in Rule 56 of the Federal Rules of Civil Procedure. Each state has its own summary judgment standard. However, I would say a supermajority of the states use the federal standard, and there are still a few outliers. Florida was probably chief among those outliers until May 1st, but that is no longer the case. I don't know off the top of my head the handful of states that are the holdouts, so that is generally correct. There, I would say there are probably a few states that have their own summary judgment standard that is not necessarily tied to the federal standard.
In some of our classes, we talk about the importance of moving some cases to federal court. That's why I want to bring that up.
Sure.
Yeah. Because this would be one of the advantages at federal court.
Yeah,
and the states, that's the reason I brought that up.
Yeah. So the take-home message, Tommy, is to all the, all of your members out there is that Florida's getting better. Brings more insurance markets. And obviously it's going to take a while for this new summary judgment rule to have an impact on the insurers, but we're very excited about it. It was a really important case. It ties the statutory curbing lawsuit abuse to the case law, and so we're underway. It's important to keep this going, keep pushing along with the support of all of your audience and members.
So Jay, the important part here is the documentation, right? And how the better documented it is, because you have to have the compelling evidence that the jury would believe versus the counterpart of it. And so we have the ability to do that. Talk how, and you and I have talked favorably in this for a long time, but this is just another reason that this should be a standard in our industry.
Yes, so statutory case law that John just told us about. And hey, John, what if Wilson Art didn't have these forward-facing event recorders? We would have never had the Wilson Art case. And so it's even more important for the insureds out there to have these forward-facing event recorders. And so we continue to say, and Wilson Art's proof certain, that, hey, should I have this? Should I not have this? Is it going to cause me more hurt and more harm than good? Look at Wilson Art. Look what's happened there. Tommy, we've been having this conversation since the beginning of MCIEF. If you remember, should we have a forward-facing event recorders? And we come a long way in this period of time. And I don't know that that's really arguable much anymore, but we again encourage that. We think it has a positive effect. Wilson Art's proof of that. However, let me add a word of caution, is that event recorders need to be surrounded and supported by good policy inside your insured motor carriers. And as you know, we do a lot of structuring and restructuring and writing of these policies inside motor carriers. And oftentimes I get a very blank stare, right, John? When I say, hey, let me see your records retention policy. But when you have recorders like this, there needs to be thought, and there's different camps about, for instance, Tommy, how long do you keep this information? What are you using it for? And so having a well-written records retention policy, because you don't want to keep this stuff forever, is really important. Secondly, contracts. For instance, independent contractor agreements with your owner operators. How do you address that? In the things that we talked about earlier, including like misclassification. So records retention policy, contract, the providers, by the way, of this technology. There needs to be good conversation about, again, how long are you keeping it? I've got a case going on right now in Texas where the motor carrier had a policy and just properly destroyed the record of a particular information, and guess what? The provider kept it forever. Provider gets a subpoena. We've been testifying on record. Nope, we don't have that information because we don't keep that information because we're not supposed to keep that information. And there is no information, and all of a sudden here it is from the provider. So really important, something to think about as we tie together the good news for instance, the Wilson Art case, and how this can be powerful for your insurance.
There's two tendencies here, though, before we talk about different type of event recorders, and I agree with some of our insurers would want to get rid of the stuff that's bad evidence and save the good evidence, and that will be a problem. The second one is, and we'll talk about here, because I don't think we want the individual driver to buy their own event recorders, the GoPros and the stuff you find at the truck stop. It's got to be one that will be even for owner operators or independent contractors, Jay, one that's owned by the motor carrier, and it's their information, because that's the one who will have to preserve everything, the good and the bad and the ugly. And so let's talk about the different types. I mean, I assume you agree with that part of it.
Yeah, you know, but you said a couple of interesting things there that I want to make sure your listeners hear, is that these event recorders need to be, again, policy bound and properly used. Maybe training, some do, some don't use it for that. How long do you keep it? But you know, independent contractors may have GoPros, Tommy, and remember, we don't control independent contractors and what they can and cannot do. That's a whole different problem. So, but if we're providing this technology to the independent contractors for safety purposes, or insurers require it, whatever the case may be, we have a little more ability to dictate the proper use of those.
Well, and also, again, and you can even cement that even more if the motor carrier furnished those event recorders for the independent contractor and paid all the fees and things like that. That would take the economic risk away, particularly the forward-looking ones. Let's talk about, you gave us a list of the ones, various types. The most common one is the forward-looking one. That's where you might have a GoPro and all that kind of stuff. You know, I like the term event recorders. Everybody's calling them cameras. Truly, they're cameras. But the original starting point is event recorder only records, what, 7 to 8 seconds before and after an event that sets it off, which is something that the gyro would what I use examples early on hearing from Linux and others is if it would spill a cup of coffee sitting on the armrest, then that would set it off. And just recorded those, and it's not all the time and not what's around. So all that would be able to be produced in court would be the 7 or 8 seconds before or after something set it off. And that's the most common one here. And that one, those, though, a lot of these GoPros, Joe, the stuff the driver buys in truck stops will erase after a period of time, which is the worst thing you can do, because you might have had the good evidence at one point, but after the fact, you might have the cleanup and not the other stuff happening. So the quality. The one I have seen that would be a standard I have, and again, we have our friends J.J. Keller and Tom Bray is going to be a part of the annual conference, but they have one for about $155, $160. That's a true event recorder. I think that's the first one, and that's the one you talk about that was in the truck that John just talked about that saves that or made that case more favorable for the insurer and for the motor carrier. That's the one that we feel everybody should have, correct?
Yeah, I think the idea of not having a forward-facing event recorder because it's going to cause more harm and litigation has been rebutted, including the Wilson Art case. And so, you know, I like to see insurers require this technology, and they support it, Tommy, as you know, in many different ways, including financially. Because it pays off. I have many cases where the story would have been a whole lot different from plaintiff, but for that event recorder, and it gets cases resolved. And listen, back to what I said earlier, it's the motor carriers want to do the right thing. Look, if the event recorder shows the motor carrier, the driver's negligent, that case needs to be resolved. Cut out the attorney's fees, get the case resolved. And we've seen that as well, Tommy. So we're seeing both sides of it. So the bigger problem, I think, comes with your next little bubble.
Well, I'm going to stop what I'm saying, John, just because that's a great point, Jay, because that's the way, that's of all things, event recorder, the one positive thing that will save insurance money unquestionably is that we're at fault, we'll start paying and not paying lawyers. I mean, even when you've had too many court cases like the one we just talked about, even when it shows we did nothing wrong, we had to go to court to get dismissed and use those facts. And there's some facts with the opposite of tort reform or reptile theory that we end up having to pay even when our insured did nothing wrong. So the one positive part that saves money all the time is when we did something wrong and we don't have all the costs to defend things, we start settling early on and get rid of it soon. And that's favorable for everybody, that part. So that's the point out here. The second, and that would be, one person in one truck should have that. And I agree with you. It has nothing to do with privacy. It's just tracking what they have. The next one you're talking about is the rear one, and this is the one that a lot of people have some objections to because it's quote invasion of their privacy inside that cab, which a lot of them don't understand. That cab's a workplace, and their employer has a right to the inside. And the federal act, you could argue that you just said a defense that they are the employee of the insured as far as they're operating the commercial motor vehicle. And that's a debatable one. And that's in there usually for training purposes, is it not, Jai?
Yeah, well, you look at this and you call it there forward facing or rear facing. So that listeners are clear, we refer to it as driver facing event recorder. But the driver facing event recorder acts like the forward-facing event recorder. It doesn't pop on until there's some event. And so it's not spying on these drivers. It's doing none of those things. That's not what we want to do. And yes, it can be used for training. That's oftentimes what the driver-facing event recorder is for. But, again, if you have well-written policies and you deliver those policies in a meaningful way so that these drivers understand most of the time, as you know, it's not the commercial vehicle, it's the four-wheeler. It's the non-commercial vehicle that caused the crash. And so this is a way to protect these drivers. And no, there is no expectation of privacy in that cab. So it's not a legal issue in that sense. And so two things. One, we're not spying on you, and there's no expectation of privacy. Just do your job, and most drivers do just that. However, and your listeners know that many of the motor carriers out there are still not using driver-facing event recorders because we still don't have the buy-in, including from the drivers, because of some of the reasons, including privacy that you just mentioned. And last thing, and it's very disturbing to see, is when we do have these driver-facing event recorders, too many times I'm seeing the driver do what? Take their hat off and put it right over the recorder. Kid you not. And so that's worse than not having it, because obviously that driver's got something to hide, and an event happens. And so training, we're still working on driver facing, but I think it can be a great training tool as well if it's properly bumpered, held in by good policy.
I've heard, and those are recording those, but now a lot of them say they're connected to the cloud, which tends to make this information available immediately. We did a class a couple of weeks ago with a loss prevention person from Nationwide E&S, and they had a situation where they got to a crash scene early enough that as the officer was writing the accident report up, they were putting the vehicles in a location that they ended up with, not where they started with. And they were able to access the information of the camera from the cloud to show the officer to redo that diagram, which kept it out of the court cases there and made the diagram more accurate. So I think this is the new revelation, where you now can have it at the cloud, which makes it immediately available for review by an officer or someone else, as well as a better retention of the records, because now you got a third party or the cloud retaining them. So there's not as easy to show. It's easier to show you got all the records there, not just the ones you want to produce.
Hey, Tommy, and I should tell your listeners this. I did a webinar somewhat recently. There's technology now that's not only cloud-based, but it's just in time, if you will, where in fact the driver-facing recorder, if a driver picks up their cell phone,
right,
alarms go off. And so there's that type of ability, if that's what the motor carrier chooses as their training. But So yeah, it can do from event to things like that. Or for instance, if the driver's nodding off, alarms go off because of this technology. So check that out. That technology is out there now.
Yeah, I've seen some of that stuff, Jay. We did a webinar on that a couple of the last 2 truck stops ago about some of this technology. And that's where they even had the driver scorecard. And when they stop, they can send the driver notes to improve or not improve. Now, I've heard some debate from mainly loss prevention people from insurance carriers on the negative side of that. So now you're seeing the driver do everything, not just that one event that set it off. And if they have a preponderance for running a red light or going too fast or other things that can record, how's that going to be later in court cases where now you're not only saying maybe they did everything right at that event, but you now look at the driver's habits that were reflected by all the continuous recording and scoring and availability. Now, you think that'll hurt us in court, and particularly if now your motor carrier doesn't take action when there's things that are wrong.
Right. I mean, information is powerful, isn't it? And so if you don't have a solid record retention policy that avoids spoliation and those types of claims, well, we're back to that slide we did earlier in the slide deck. But if you keep everything forever, and that is discoverable, and certainly plaintiffs can and will use that against motor carriers. So it's, again, common sense, good policy, whether it's that advanced technology or the technology that's more used today. Again, it's common sense in that regard.
But that gets back to the slide you used earlier about about having a reason for this and the discipline and consistency in that for the training purposes. And if you can document those kind of things and they're taking those actions, that takes some of the negative part away, because then you turn this information to a positive to help the driver or to remind the driver, just like nodding off. I mean, golly, my comment has always been, Jay, that I'm qualified. I'm physically able to drive a truck. I just can't stay awake 11 hours. Now, I drove from South Carolina with a granddaughter's graduation. My truck stay yesterday, I drove exactly 11 hours. I worked 12, counting the truck stops and other necessities on the stop. So I had a trucker's day yesterday. John, let me ask you a question going back to the example of the case that you just did. We're hearing a lot also the advantages of cameras 360, front, side, and back. Particularly and I heard some lawyers talking about finding those fraud cases in Louisiana, where one of the advantages there, they finally installed some 360 and they saw those intentional running inside the truck that helped them make that case even more in Louisiana. Again, that's not all that costly, and that obviously in the Florida rule, where it's a preponderance of that, if you get running in the back, it's the four-wheeler's fault. But if it's a gray part of it, and say there weren't stopped and you know, sudden here, if you had a rear camera, that would have even been more evidence of what happened. Would it not been if you had a rear-facing camera also, as well as a front-facing camera? And when I'm saying rear, the rear of the trailer. Again, you're right, Jay. I should have straightened this out. When rear-facing, I should driver-facing versus rear being the back of the trailer.
Yeah, I think you're right. I mean, any more information you can have that would disprove what the plaintiff is putting out there is going to run to the benefit of the defendant driver and the company who's being sued vicariously. So in the Wilson Art case, they didn't have, it was a forward-facing camera. They didn't have a 360, but they didn't need it. They had enough.
Right.
They had enough there. Look, the presumption. This is not a legal presumption, but the inherent bias is always going to be that the big truck caused the accident. I mean, that's just that's what plaintiffs' counsels rely on when you get in situations like this. That's why the estate of Mr. Lopez, who clearly hit the back of the Wilson Art truck, still sued Wilson Art and the driver because they're taking a shot in some respects, because again, people see the big truck involved in the accident and they think that the driver and the truck is responsible, and that's not always the case. And when you have video to dispute that, it's powerful, and you just may find yourself out of the suit especially now in Florida, you might find yourself out of the suit a lot faster if you have that type of evidence as opposed to not having it.
Yeah, and one other thing here, even though they might not be successful in court, I know the mindset of most claims adjusters, they would have been willing to pay $50,000 or $100,000 in that case just to get rid of it, not to have to defend it if they did not get it dismissed. You know, that's always the mentality. How can we get rid of it at a lower number here, even with positive evidence? Jay, we've talked about that often too, and on the Road Dog show that you and I do together. Why do you pay things you shouldn't? Well, because we're in the business of spending less money, the least money we can, and if I can get out of it versus paying attorneys or construction, accident reconstruction, not get out of it up front, I might as well do it now versus a year from now.
Well, you know, and I want to emphasize something John, I thought was a really good point, was saying there is that, you know, Lopez's estate brought this lawsuit. There was a plaintiff's attorney that brought this lawsuit, notwithstanding this evidence. And, you know, we talk about curbing lawsuit abuse, we talk about the case law, but Tommy, we got to address this attorney advertising. Folks are sitting there all day long, and, you know, the Texas Hammer is got commercials, or, you know, Morgan and Morgan.
Well, the size makes a difference.
Right, you know, all of this ridiculous advertising.
I'm quoting a billboard for anybody's listening. So I'm putting up my own personal judgment now.
Right, you know, and you know, so that's got to be addressed as well, because folks need to understand that this is not a lottery system, and that's what it's almost portrayed as. You know, Dan Newland got me 750,000. You know, there it is on the billboard, and so that's got to be.
Let's do a class action suit, because I also had some of those claimants, he said, that put that in my pocket. I promise you that number he put up there is the gross amount, not less his the third or half. That never really got to the claimant's pocket.
Not only there's no truth in damages, there's no truth in advertising, and so maybe that's the next big thing. I know. And I hear and I'm seeing some attention being paid to that. So stand by on that. Maybe that's another good truck stop one day.
Anyway, you mentioned the very last, and we don't do enough of this, Jay, and I appreciate you talking about how important it is to support the local trucking associations, not only in this effort, but a positive thing, because we hear such a negative situation I was listening to another show as I was driving home yesterday, not one that we have been on, the one after that, and they're talking about how insurance, you know, is not fair, 8,000 here and 33,000, and they didn't understand the difference in a food grade tanker being harder to insure, all this other kind of stuff. So the more we get to the trucker themselves to say all we're doing is reacting to what we have to do, and that's pay out. And anything you can do to help us both with tort reform and trucking with evidence like we talked about here, the better it is for us. And eventually that will lower the cost of insurance, because we don't have to pay so much. This is not a for-profit organization. And the reason things are so costly is because of the cost of paying claims and the cost of insuring interstate for-hire motor carrier.
Yeah, so, you know, the take-home message for your listeners, hearing about some sampling of the statutory side, hearing John's presentation on the Wilson Art case, talking about all this. Tommy, but for the Florida Trucking Association support, William Large and some of those folks that were involved in this Wilson Art case, this would have never happened. And this support by the members of the Florida Trucking Association is critical. Hey, Tommy, every single trucking association, all the different states ought to be packed out for every meeting, including from your listeners, the insurers, the retailers, everyone, the MGAs should be critically involved in these associations, because that's where the lobbying happens. That's where the education comes in, some of the things we talked about today. So please, listeners, please, today, Get involved with your local state trucking association here in Florida. If you're interested, you'll see my email in a minute. Email John or I, and we'll get you connected with an association, whether it's here in Florida or Texas Association. It's the same thing. I don't know if you've seen the commercials, but the trucking association there in Texas has been critical to the curbing lawsuit abuse there. Please, today, get involved.
And wherever possible, offer them educational programs, either done themselves or the foundation can provide one at no cost to them other than the expense of doing it. But that would be a move that we would try to make. Jay, here's your firm information. You've been a true friend from day one in our foundation and this part of it. Say a couple things about your firm, and also Jay will be with us at the annual conference. We're working on a couple good subjects for him for that, and so we look forward to seeing you in Orlando in person instead of on this beautiful, instead of the pictures we have here. And I'm glad you introduced John. I'm sure we can figure out something for you to do before it's all over with, because between Jay and I, we try to maximize as many people who are willing to give up their time as possible. But
Absolutely.
to stay briefly on this, Jay, and thank you for your efforts in this.
Oh, and thank you, and to the foundation, who is a voice of the insurance world and the motor carriers. You've done a great job. All the members supporting. Hey, listen, I'm looking forward to seeing everyone in person. And if you haven't signed up, you better, because you know it's going to sell out again this year. So looking forward to seeing everyone. Thanks, Tommy. Thank you, John.
Thank you, Jay. We really, really appreciate it. And for you who are part of this, this information again is offered by MCIEF, Motor Carriers Insurance Education Foundation. That will be for memberships, the TRS designation, trucking you and other classes. If you want to know more about it, here's our website, and you can follow us on LinkedIn and our social media. So this is in. We'll see you next month for another webinar.